Okay, good afternoon. Ms. Hall, are you able to hear me?
I can, Your Honor.
Great. We're going to get started with our 2 o'clock calendar. 3 seconds early. You good, Mr. Forte? All right, Mr. Gardner, you made it here. Yes, sir. Great. Mr. Rosenblum, how are you doing?
I'm doing very well, Your Honor. I received great news after surgery. They got all the cancer.
Fantastic.
And clean as of last week.
Okay, that's a phenomenal update. That was scary news we got from you, and I hope you took the time you needed to address, and it sounds like the doctors took the time they needed to address what they needed.
I was diagnosed on a Thursday. I had surgery the following Tuesday.
That's swift medicine. You may not be dealing with swift justice here, but it's swift medicine for you. Mr. Gardner has traveled there, I think, from Alabama. Is that correct?
Yes, sir.
Okay. You can move the microphone down a little bit so you don't have to stretch. I think we met online. We had a discussion about this case a ways back, and Mr. Gardner appeared remotely. He's here in court along with his lawyer, Mr. Rosenblum. We have Ms. Hall on the screen there, and this case is being live fed through YouTube, so there may be victims or family members of the victims who are watching and listening. We have our victim witness advocate, Ms. Rolak, on the call as well. And I believe this is on a calendar for a plea. Is that correct, Mr. Rosenblum?
That is correct.
And I asked Ms. Hall this morning for nothing substantive other than, is it negotiated or non-negotiated? She said it's non-negotiated. Okay. Then I'm ready to go forward if Mr. Rosenblum, you and Mr. Gardner are ready.
You're ready, Your Honor.
Okay. It's going to be important that Ms. Hall be able to hear both of you, but Mr. Gardner in particular, because she'll be asking a bunch of questions of Mr. Gardner. Mr. Gardner, why don't you say your name into the microphone so we can see if Ms. Hall can hear it.
Marcus Gardner.
Wow, I think they could hear that back in Alabama. Were you able to hear that, Ms. Hall?
Yes, Your Honor.
Okay, that's going to work then. Mr. Gardner, in just a moment, Ms. Hall is going to put you under oath. Once you're under oath, it's important that you answer all of her questions truthfully and completely. If at any point during our conversation you have questions of your own or you're just not understanding what's going on, you need to let Mr. Rosenblum or me know that there's something you need explained, or there's something that the two of you want to discuss. We'll take a break, and you and your lawyer can talk. Okay?
Yes.
Great. Well, then with that, when you're ready, Ms. Hall, let's get started with the plea colloquy.
Thank you. Mr. Gardner, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
And I can, please state your true, correct, and legal name.
Marcus Nigel Gardner.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
51 years old. I have a Bachelor of Science degree in computer science and computer information systems.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Fleeing and attempting to elude, 2 counts of aggravated assault upon a peace officer, 2 counts of driving, hit and run, 1 count of interference with government property, 1 count of driving expired or no license plate or decal, 1 count of failure to obey signs or control devices, 1 count of obstruction of a law enforcement officer, 1 count of attempting to misrepresent a tag, and 1 count of failure to keep in proper lane.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney, Mr. Rosenblum, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss his case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
We so waive.
Do you waive any and all defects in the indictment, including with respect to the defendant's name? Uh-oh. Did you answer, Mr. Rosenblum?
Yes, I waive all defects, including.
Okay. I'm sorry, I missed that one. And also, do you waive moving forward on a copy of the indictment?
We so waive.
Thank you. Mr. Gardner, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Has your attorney advised you of the minimum and maximum sentence to each charge that you're pleading to?
Yes.
The minimum maximum for fleeing and attempting to elude is 1 to 5 years to serve or a $5,000 fine. The minimum maximum for aggravated assault upon a public safety officer while engaged in official duty felony is the minimum is 5 years, the maximum is 20 years to serve. The minimum maximum for interference with government property is 1 to 5 years to serve. And the maximum for driving hit and run, driving expired or no license plate or decal, failure to obey sign or control devices, obstruction of a law enforcement officer, attempting to misrepresent a tag, and driving failure to keep in proper lane are all 12 months to serve. Do you understand?
Yes.
Do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state will still recommend a sentence to the court?
Yes.
Have you discussed this offer with your attorney?
Yes.
The state's offer for fleeing and attempting to elude is 5 to serve 1 year, balance on probation. The state's offer for aggravated assault upon a public safety officer for both counts is 10 to serve 1, balance on probation. The state's offer for interference with government property is 5 to serve 1, balance on probation. And for all remaining misdemeanor counts, the state's offer is 12 months probation. All charges to run concurrent to each other. Do you understand, Mr. Gardner?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each of these charges?
Yes.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering the plea of guilty?
Yes.
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the charges of driving, fleeing, and attempting to elude, two counts of aggravated assault upon a public safety officer while engaged in official duties, driving, hit and run, interference with government property, driving, another count of driving and hit and run, expired or no license plate or decal, failure to obey signs or control devices, obstruction of a law enforcement officer, attempting to misrepresent a tag, and failure to keep in proper lane in indictment number 19 SC 166725.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, the state is unaware of any prior felony convictions by this defendant. And had we proceeded to trial, the state would have proven that on March the 31st, 2019, I have a cross street, which is Roswell Road at, I'm gonna spell it. It's D-A, I believe this is a L-R-Y-M-P-L-E
Pronounced Delaware.
Road in Sandy Springs, Fulton County. Officers observed Officers have observed a vehicle, ran the tag on that vehicle. That vehicle came back registered to no registration on that vehicle. I'm sorry, Your Honor. My apologies, Your Honor. On that day, officers observed a vehicle, a red truck. They ran the tag on that vehicle and it came back to a different vehicle. When they tried to pull over the defendant kept going. The officer turned on his sirens to make sure that the defendant knew that he was attempting to pull him over. The defendant at some point, this happened in Sandy Springs. He pulled into a gas station, to a gas pump. He did stop his vehicle, at which point one officer pulled in front of the vehicle and there was another officer behind his vehicle. He did manage to still get around those two officers, but he did strike one of those vehicles when he ended up putting his vehicle in reverse and hitting one of the officers' cars. The officers continued to pursue this defendant. He went into an apartment complex where he was essentially blocked in again. When he noticed that someone was coming through the gates of that community, he did go through that gate to get out of that apartment complex, at which point he drove down a road and was met by a dead end, at which point the officers that were following him ordered him out of his vehicle. They did get out of their vehicles, and the defendant at some point tried to hit another vehicle, another officer's vehicle. He did go towards those officers who were outside of their vehicles. No one was actually injured in this incident. When they did eventually get the defendant to get out of his vehicle, he grabbed a bag that was in the passenger seat of his vehicle and did exit his vehicle. He never listened to the commands of the officers to get on the ground or stop moving. He actually was approaching one of the officers. That officer I spoke with said that he felt as though he didn't know whether the defendant had a weapon on him or was going to pull a weapon. They didn't want to shoot the defendant at all, but they did feel like the defendant may have had some type of weapon that he was going to pull when he was ignoring their commands. They did not eventually find a gun, so there was no gun that was recovered from the defendant. But he was eventually arrested, Your Honor. During this time, the defendant was acting in such a way that paramedics were called to the scene. He was transported to Grady. I did receive medical records from defense counsel about his medical condition during this incident. That's what pretty much has had us stuck for a very long time for this case. I read the medical records. It does appear that he did suffer some type of heart attack or something during this incident, but the state's contention was that it happened maybe during the running from police instead of before. And at some point we were stuck at a 10-2 non-negotiated plea. Now that we've been through this pandemic and it's been such a long time, the defendant has been out on bond for now almost a year and a half. We did decide to go down a year on our recommendation, although we're still asking for prison time because of everything that did happen from this. This was a high-speed chase through the city of Sandy Springs that took a while to get the defendant to stop. I do know there are a lot of mitigating factors that defense counsel will explain to you, but from our point of view, we're still stuck at the 10-1, Your Honor, and that is all from the state.
Ms. Hall, so no officer was struck directly, but one patrol car at least was struck in the gas station.
Yes, Your Honor, and I'm sorry, I didn't make that clear. A police vehicle was struck twice by the defendant, once at the gas station and once before he was arrested. At the time at the gas station, there was an officer inside of the vehicle, and then there was no officer in the vehicle that was hit the second time. But from those encounters, there were no injuries from the officers.
Okay, but the one Sandy Springs police car was hit in a gas station.
Yes.
And Mr. Gardner kept on going. And then he ultimately got in this dead end situation. Is that when the second police car was hit in the dead end situation?
Yes, Your Honor.
Okay. And then you described Mr. Gardner getting out of this red truck with the license plate that doesn't match the red truck. And he's got a bag in his hands and he's approaching the officers. Did we ever find out what was in the bag?
No, I talked to the officers. They just because this is a case that the defense has been trying to get probation on. So I talked to multiple of the officers that were involved to try to understand if it seemed as if the defendant was having a heart attack. I mean, none of us are medical experts, but just their opinion on it. And they said during the time when he got out of the vehicle, he grabbed the bag, but he was not complying to their instructions to stop. He just started walking towards one of the officers as if, in their opinion, he was going to do something further than just try to, then allow them to arrest him. So that's all I got from them. They didn't give me much more than that, just that they felt like that situation could have been similar situations where it ends up in deadly fire or something like that. So that's
Sure.
where the
Sure. It sounds dangerous on lots of fronts, dangerous to Mr. Gardner, dangerous to folks driving down the street, and he's flying along in this red truck. Did you get a sense of how far, ballpark, I don't mean 2.1 miles, but there's this intersection, Roswell and Dalrymple. Police figure out, wait, there's something wrong with this truck. Tag doesn't match vehicle. So they start following him. And ultimately, after the gas station escapade, going into an apartment complex, getting out of the apartment complex, and avoiding the police, running from the police, ultimately there's the dead end situation. Was this a 10-second trip? Was it across half of town, or what sense did you get from the officers?
Talking to the officers and reading the report, it doesn't seem like this was a very far distance. It seemed like it was a lot of citizens involved, as in going through a gas station, but it seemed like to me that it wasn't a very like a long 20-minute chase or a 10-minute chase around Sandy Springs. It seemed like it was a small proximity of the actual chase. But I did not ask specifically on that question. This is just me gauging from reading more. The report is very long, and I apologize if I left out some significant facts. I tried to summarize as much as I could, but they list streets and everything in the actual report, and it didn't seem like he traveled that far from that.
Got it. All right, well, I appreciate you summarizing. That's helpful. Ms. Crawford, good afternoon. Do you have any criminal history for Mr. Gardner?
Good afternoon, Judge. Mr. Gardner has no criminal history.
Okay, thank you so much. Mr. Rosenblum, why don't you share with me what you want to about Mr. Gardner and this situation and why you think a probated sentence is appropriate.
Thank you, Your Honor.
And let me make sure, it's great that you're at the podium, get that microphone as close to you as you can. I need to make sure Ms. Hall can hear you because I may ask her to respond to some of the things you say.
Certainly. Testing, 1, 2, 3.
Really?
I can hear.
Great.
Good afternoon, Your Honor. Marcus Gardner is date of birth of October 29, 1968. He is a former military veteran. He has a degree in Bachelor of Science in Computer Programming. And as Ms. Crawford already indicated, he has an criminal record. We are not here to dispute whether or not Mr. Gardner is guilty of the crimes he's been accused of. If there was a dispute, we wouldn't be sitting here with today. We'd be sitting with the jury at some point. What we are disputing is whether or not there were mitigating factors involved that make jail time, even at the reduced rate of a year, unnecessary and doesn't make sense. Mr. Gardner did in fact suffer a very powerful heart attack that day and was taken to Brady, and he had 4 stents put in his heart. Heart surgery. He was recovered at the Fulton County Jail, which, having had my own medical procedure in the last month or so, I don't think that sounds like a good place to recover from.
When is it your contention that the heart attack began? We've got a string of events, starting with the basic minor crime of driving a truck that has a tag that doesn't belong to the truck. So heart attack or not, we're already starting out in a strange situation for a guy from Alabama with a college degree. What's he doing in Sandy Springs driving a red truck with the wrong tag? And then in the stream of events that you heard about, where does the heart attack occur? Because it didn't sound to me like Mr. Gardner was incapacitated as he eluded in a crafty way out of a gas station into an apartment complex, out of an apartment complex. This is not someone who is lying on the floorboard of the car, unable to move.
I think this was a ticking time bomb that happened, that Mr. Gardner has advised myself and my partner that he had actually left work that day because he wasn't feeling well. And he does live in the area, so it's not like he was coming from Alabama and he does work and live in the area. The stress of being pulled over by the police for whatever reason may have started the clock down. By the time he got to the stop, after everything going on, the heart attack was already on its way, or it had already started. You never know. everybody's different, so we don't know how long, heart attack sounds like that, which we all know that's not the case. In watching the video and listening to the EMS report, at the video, his blood pressure was so high, they couldn't consider anything other than taking injury. There was no questioning that he was in some sort of cardiac trauma. So and again, just like Ms. Hall, a doctor, as much as I would say it's a doctor of law, that doesn't mean the same thing. I would say that this was, it started during it, probably exacerbated the situation. And even though my limited medical terms, I know that a heart attack does stop the flow of blood to the brain, among other places, which would lead to common sense issues as much as leading a police chase. This was not a long-term, as Ms. Hall indicated, this was not a long event. I think the whole video from the pullover to the stop before we got to the point, this was in 3 to 4 minutes. We don't know if my client was in full comprehension of his cognitive skills that day, but we don't have any evidence to support that either. And that's not why we're having a trial, that's why we're having a plea. My client suffers from heart failure and hypertension. We do have a doctor's letter stating that. And his opinion is that if he were to be exposed to COVID-19 in the prison system, along with his regular medical conditions, which again, the jail is not the best place for it, is a death sentence. I don't mean that lightly, and I don't mean that not mean anything else. He has no history. I don't see putting him in jail, even for now a reduced sentence of a year, serves the public, serves the state of Georgia more than him doing community service, remaining on probation, doing something to pay back the community, including the police department of Sandy Springs, by being productive. Sitting, wondering if this is going to be today is not productive to anyone. And based on validated circumstances, so to speak, I don't believe a prison sentence, even though a year is reasonable at this time. We would ask that we put on straight probation, whatever terms the judge feels is necessary for probation. I find him more than willing to comply, and we would also be asking for this to be a first offender, since it is in fact a black criminal record, and I give it.
So how we work through Mr. Gardner being in Alabama, Mr. Gardner being in or near Sandy Springs. I understand this was March of last year. Since then, your clients moved to Alabama?
Relocated due to the fact that I believe there was a layoff. He was laid off from his job, so he returned home. At the time of this incident, he was working as a computer programmer in the Atlanta, Georgia area.
Okay.
That's what places him in Sandy Springs. He lived in the year.
Okay. So, Mr. Gardner, what's going on with the funny license plate on the red truck?
We trying to figure that out, and we have no idea how that happened.
Who's we?
My family, and the truck is in my name, but I still don't have a clue how that license plate get out here.
Well, I have a red car, and it has the license plate on it that it's always had. Did you at one point have a different license plate, or what? Tell me.
Well,
I'm not real persuaded by that answer.
Well, it's the same exact license plate, is like the color, but I rarely check. I never check the numbers on it, so I just assumed it was the same license plate.
Okay. I mean, I don't check mine either. It's just mine stayed the same. It didn't change.
Right. So,
Do you think someone swapped license plates?
I have no answer for that.
Okay.
I actually have no answer for it, and that is just like I told Mr. Rosenblum. I don't know how that license plate ended up on the truck.
At the time of this incident, so March of last year, where were you living?
I was staying in extended stay because I had just moved back to Atlanta to work in OTR, which is on-road trucking, and so I'm working on the computer program. So
you were in temporary housing.
temporary housing at that point.
Okay. And your red truck, did it have an Alabama license plate on it or a Georgia license plate?
And Alabama.
Because home was Alabama, but you were relocating here.
Right.
How long?
Well, I've lived in Atlanta before, and I was coming back here to work because I got an opportunity to work at OTR. And so I was coming back to work, and I was staying in a extended stay hotel until I got a place to stay.
Okay. How long had you been staying at the extended stay hotel when this happened?
About 6 months.
That's an extended stay. So you've been here for 6 months, and was it not clear that the job was going to become permanent, or why had you not found a?
Well, my plan was to stay there about 6 months and then find me a place in Parkville or something. But this happened about maybe two days before I was about to actually make my plans. So I was in the process of saying, okay, I'm going to move to the Parkville.
Okay, and you're now back in Alabama
For now,
for now. Do you still work for OTR?
unfortunately, no.
And why is that?
Well, we experienced layoffs because of COVID, and I'm currently looking at possibly trying to do some remote work, software developer, but most likely I'll probably find a brick and mortar situation. So, but no, I'm currently not employed as software developer.
Okay. The heart attack that you experienced during or soon after this incident, was that the first time you had a heart attack?
Yes, yes, sir. But I have been having symptoms that I was not aware of. Symptoms of breath, dizziness, and my coworkers actually had told me to that I should go to the doctor. And I kept putting it off. And I kept saying, well, I'll go next week. But I was having difficulty breathing and dizziness the whole time. And so, it was my first heart attack.
Okay. I'm glad you survived. Ms. Hall, I assume there's no restitution because the state doesn't get to collect restitution. I mean, the things that were damaged were Sandy Springs, but it was state property. So a fine may be appropriate, but there's not restitution in this case.
That's correct, Your Honor.
Did you get a sense of how badly the patrol cars were damaged? I mean, was it the kind of thing where there was a little scratch, or the whole front end was total?
The cars weren't total. They did have some dents in them from him ramming them, but it wasn't a total type of situation at all.
Got it. Mr. Rosenblum, there'll clearly be a probationary part of the sentence. It's what you want, and it's the bulk of what Ms. Hall is asking for. How do you envision that working? Mr. Gardner is right now an Alabama resident, but probation has to start in Georgia, to start in Fulton County.
He has family that he can stay and to get signed up and make arrangements for that. It's a reasonable thing that has to do, and we would ask that he be allowed to report in Alabama under their auspices or however the state feels appropriate.
Sure, well, and someone will talk to you and Mr. Gardner about that. In fact, it's Ms. Crawford. We did that earlier today with someone wanting to be supervised in Michigan because that's home for that person. So transferring supervision should not be an issue. This isn't the type of charge where the receiving agent, it's not a child molestation case where that involves all sorts of layers of supervision. That's not this case. But it sounds like you've spoken with Mr. Gardner about the fact that for the probated piece of the sentence, he might need to be in or near Fulton County for a few days while they work through transferring supervision to Alabama.
And if he's got family here today, and if he can test it, they'll make sure that he is where he's supposed to be and get assist in any way, shape, or form through the process.
Sure. Okay. All right, Mr. Gardner, anything else you want to share with me?
He has prepared statements.
Okay.
Good afternoon, Your Honor. I want to first of all say that I accept full and complete responsibility without any excuse, because there's no excuse for my action. I would like to apologize to the police officer, the court, and the state. I've let a lot of people down, including my family. I'm ashamed and embarrassed that my actions have resulted in me being here. I graduated from high school. I joined the United States Navy at 17 years old. After my enlistment, I attended college and graduated with a Bachelor of Science degree in Computer Information Systems in 1997. I've been working as a software developer in information technology for over 20 years. I have one daughter and one granddaughter. And the mother that I provide financial assistance for. Your Honor, I have been feeling sick and had difficulty breathing for months, but I did not know that I had a heart condition. And then my heart was failing. All right. Several of my coworkers had advised me to go see the doctor, but I kept putting it off. So I kept putting it off. Said, well, I'll go next week or I'll go later. And so, on the day that I was arrested, I was very disoriented and unknowingly suffering from a heart condition. I was having difficulty breathing and feeling dizzy. I did not realize that I put my car in reverse. I did not try to hit the office. I was feeling disoriented and dizzy. After my arrest, I was transported to the hospital. I had to have multiple stents put in my heart. And I had to stay in the hospital for 7 days. And get my blood pressure under control, get my heart. I'm currently prescribed eight medications. I'm currently on 8 medications for my blood pressure and my heart health. Once again, I want to reiterate that I take full responsibility for my actions. I'm just trying to give context to what occurred that day. And so I ask for, of course, mercy and consideration. Thank you.
I appreciate you sharing that. Thank you for your service in the Navy. Mr. Gardner, I need to talk to you a little bit about how first offender works. I'm sure that Mr. Rosenblum has explained it to you, but we need to discuss it on the record. You qualify as a first offender. I think it's appropriate. You have made it 51 years into your life without an issue along these lines. I mean, I've been a model citizen, but who is? But this is your first time you've had a run-in with the law. That means that you can receive first offender treatment if you want it. The benefit is that when you are sentenced, which is what will happen in just a moment, it's not a conviction. You will be a first offender during the duration of your sentence. As long as you successfully complete that sentence, it remains not a conviction. So as you are looking for other work as a software programmer or anything else, you don't have to check that dreaded box of I'm a convicted felon, which, as you know, will close lots of doors that otherwise ought to be open for you because you're educated, you're experienced in the field, etc. So you ought to be hired given your background. But part of your background could be a conviction. It won't be if you're sentenced as a first offender. That's the good part. That's why people want first offender. The risk that comes with taking a first offender sentence, and both your lawyer and the prosecutor are asking for a pretty long term of probation, so you'd be under sentence for a while. The risk is that should you get in trouble again with the law during the course of your first offender sentence, not only would you have a new case to deal with, but you could have your first offender status revoked. And without a trial, you have a hearing, but it would not be a trial, and the state's burden of proof would be much lower. The judge, and it would likely be me, could conclude that you ought to be resentenced. And you have a whole lot of exposure. You could be sentenced to over 50 years in prison. Now, that's not likely to happen if, and I'm making all this up, if 2 years from now, you got arrested for writing a bad check. I don't know that anyone would turn this into a 50-year sentence. But if you ran down a police officer with your red truck in 2 years, I could see a judge saying, not only you got to deal with this new case, but here's 50 years for last time, because that old story about I didn't know what I was doing seems a lot less persuasive in light of what you did just 2 years later. So the risk is, if you're not so sure what all was behind this situation, and I hear you that you weren't feeling well, and we know you weren't well because you went to the emergency room and you got 4 stents put in. That, to me, explains some of it. It doesn't explain all of it. And so I worry that there may be something else going on, and we'll talk about that in a moment, that might make you susceptible to having a situation like this arise again. If you're pretty sure that you're going to stay out of harm's way during your sentence, first offender makes a lot of sense. If you're not, I explained to you the risk. If you were to get in trouble again during your sentence or anything like this, the judge who is handling your revocation is going to be pretty underwhelmed with what happened. Do you think you understand the benefit of first offender?
100%.
And the risk of first offender?
Yes, sir.
Also 100%.
100%.
Okay. Knowing the pro and the con of first offender status, do you want to be sentenced as a first offender?
Yes, sir.
Okay. Well, we'll do that. Mr. Gardner, Mr. Rosenblum, question for counsel. You can share with me what you're comfortable sharing. I want to make sure that as we structure this sentence, we're addressing all of your client's needs. And I want to make sure if you have any concern that there ought to be some type of evaluation or treatment that would assist Mr. Gardner with other issues that might have been at play that day, that we address that. I heard you loud and clear with a heart attack. If there is an addiction, a substance abuse issue, anything like that, that partly explains this. It doesn't justify it, but it explains it. We, as a group, would be remiss if we aren't taking this opportunity to address it as well. Because I'm just trying to figure out how all these different things would happen with a 50-year-old upstanding citizen working hard, minding no business other than he doesn't have the right license plate on his truck.
Nothing I have seen in my interaction with Mr. Gardner since this has started, my review of the file, my speaking to the medical providers, review of the medical records indicate that anything else was going on that day other than perhaps the disconnect. In speaking to Mr. Gardner over this time, based on my training experience as well, I was in the treatment diversion court when I was a prosecutor here in Fulton County, so I've got some experience. Nothing struck me as a red flag, so to speak.
Okay. I asked just to
On
be
the other hand,
careful. I'm not.
Your Honor, I believe that most, if not everyone, needs some sort of counseling and dealing with, and perhaps while he may not have needed counseling prior to this, with everything that's been going on, I would say that it would not be a bad thing to include a counseling portion to his probation, just to, if anything, help alleviate any pressures and concerns going forward so that we don't have any problems.
Mr. Gardner, you went to the hospital immediately following your arrest in this case. You told me you were there, I think you said 7 days. I heard Mr. Rosenblum say you also recovered some at the jail. How long were you in custody before you posted bond?
I think about 3 weeks?
Yeah, it was approximately 3 to 4 weeks. We were able to get in touch with the district attorney at the time. It was Mr. Royals, and I provided him the doctor's notes and everything. And we were able to come to a consent bond, which
Okay. All right. Well, Mr. Gardner, I find there is a factual basis for your plea. As you said, you're accepting responsibility for each step of the process we heard Ms. Hall describe. It sounds like from officer testimony and probably video footage, the state would be able to prove up all the things that are alleged in the indictment. You might have a good argument about intent, at least for parts of it, insofar as you were in medical distress. But as I've emphasized several times, it's too many separate pieces of ignoring what the officers were asking you to do to, I think, have a airtight justification defense. And I suspect that's one thing Mr. Rosenblum has told you. So we go to trial, but after a while, the jury's going to say, well, that might explain this part, but it's not going to explain it. So there is some other piece to this that I'm never going to fully understand as to why you didn't just stop and deal with whatever it was the police officers wanted to talk to you about. I'm glad you didn't get hurt, man. You got a heart attack, but you didn't get more hurt than that. Particularly glad no officers were hurt, and most of all, no innocent bystanders. No one got run over in the gas station. No kids playing in the apartment complex got squashed while you were doing your utmost not to stop for the officers who were trying to address. Who started out as minor as the tag didn't match the truck. Those are all good things, but it's still a disturbing set of facts. I also find that your plea is knowing and voluntary. That means on the voluntary part that no one has forced you to enter this plea, but that you've decided of your own free will to enter the plea because you think that's the best way for you to move forward. Is that correct?
Yes, Your Honor.
Okay. And a knowing plea is one that's made with a full understanding of the consequences of the plea, meaning you've understood all the things Ms. Hall explained to you about the rights you're giving up. Is that correct?
Yes, Your Honor.
Okay, then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, whether it's here or in Alabama, that if you have a technical violation of your probation, maybe you are a little behind in doing some community service or you miss a meeting, you and probation can work that out. You don't have to get dragged into court to get in front of a judge. But if it's more serious, if you are arrested again for anything, those types of allegations would get you back in front of the judge. Mr. Gardner, I'm going to tell you the overall sentence, and then we can break it down into all the little pieces. I'm going to sentence you overall to a term of 8 years to serve 30 days. I'm going to let you start those 30 days after your birthday. So I'm not going to sign your sentence yet. I'm going to let you go home. And as I understand, you've got the big 52 coming up on the 29th of October. You're going to go home and do that. You're going to have a report date here of November 2nd. Come to this same courtroom. I've got court on November 2nd. I start at 9:30. You're going to be here at 9:30. If you're here at 9:30, I'll sign the final disposition. That's the sentence that will have the effect. Again, I'll break it out across all the counts of 8 years probation and 30 days in here at the county jail. I want to address something that Mr. Rosenblum said about you going to jail being a death sentence. One of the cleanest, safest places to be right now, as opposed to a grocery store or a restaurant or a takeout restaurant, frankly, walking in the park, is our county jail. They have had 0 incidences of internal COVID from inmates. Every once in a while, someone comes in and tests positive, and that person is immediately quarantined, isolated, kept away from everyone else until that person is clean, if you will, on the COVID front. So I'm not suggesting that it's a fun place to be. I appreciate that you suffer from a number of medical conditions, but jail is not the preserve of only the young and the healthy. And what you did on this day is serious enough that that's why I asked how much time you've already served. I was going to say 2 months, You're gonna say 60 days in jail. You've already done half of that. I'm gonna make you do it again. But I think that it merits your conduct on this day, even though partly explained by the health situation, merits that small amount of time here in the Fulton County Jail. You won't get transported away. 30-day sentences, stay locally. So you're gonna know where you're gonna be the whole time. Family can visit, etc. In our county jail. Upon release, you'll be on probation for 8 years. You will have a fine of $2,500. You'll have to perform 120 hours of community service. You don't have to pay that fine on day one. You don't have to do those community service hours in month one. But you'll need to begin working on both, because if 6 months have gone by, you haven't paid anything, you haven't done any community service, that's the kind of thing where probation starts to get agitated, and they report to me, Mr. Gardner's not doing it. So you'll want to get to work on those things. Let me break it out across the counts. Count 1, the sentence will be 5 years to serve. Well, I need to get to 30 days in. So it's count 4 and 6 through 11 are all 30 days to serve. They'll run concurrently with each other. Count 1 is 5 years to serve, consecutive to count 4, but those years are probated. So that's 5 years probation. Counts 2 and 3 are 8 years to serve, probated, concurrent with count 1. And finally, count 5 is 5 years to serve, concurrent with count 1, and that's also probated. So the way I intend to have pronounced it, and Ms. Nelson, who was listening in, will correct me if I got it wrong, is 30 days to serve, followed by 8 years of probation. And those 8 years can be reduced. It may be that they become non-reporting, and they may even be terminated early, well before the 8 years are up, if you paid the fine and completed community service and basically done good time. If you are not a problem for probation, they don't need to supervise you. They have enough headaches with folks who don't do well on probation. I suspect you'll be one of those folks who falls into the category of not a problem on probation. So while it is 8 years probation, that can be greatly reduced if things are going well. And probation will let you know, but ultimately, it may be that Mr. Rosenblum files something on your behalf to have the probation turned into non-reporting or even suspended. And probation will be your ally on that. If you're doing well, they will support the request. But we're building in the 8 years in case it's not going well. And I want to give you time to pay the fine. I know you haven't been working for a while, and you have folks to support and time to do the community service. Again, that sentence I just described is contingent upon you being here, courtroom 1D, at 9:30 in the morning on Monday, November 2. If you are not here then, and I haven't heard from Mr. Rosenblum, it's because you're back in hospital and he's provided medical proof that you're somewhere like that, then I'm going to sign a different sentence. And that sentence is 10 to serve 1 year, 1 full year, exactly what the state asked for. So you're in charge here. I'm giving you a little time to get your affairs together, celebrate your birthday with your family, etc. To be here on November 2nd, we go into custody and serve 30 days in the county jail. If you're not here, I'll sign a different sentence sheet, sign a warrant. Eventually we'll find you and you'll have bought an extra 11 months because you won't get credit for the time you did back in March or April of last year. Does that make sense?
Yes, sir, Your Honor.
Do you have any questions about any of that? Ms. Hall, do you have any other conditions that you'd like to see on probation?
Nothing additional from the state, Your Honor.
Okay, I appreciate the work you did on that. Ms. Crawford, I know you're going to want to talk with Mr. Gardner in a minute to get his contact information, and we'll let you guys do that. Do I need to say anything else in terms of the probation piece?
No, Judge, but I'd like to go into a breakout room with him once you're done.
Yeah, we'll need to figure out how to do that since he and his lawyer are here. It might be if you have a phone number that Mr. Rosenblum could call, they could go outside the courtroom because I have another matter following this. And you all could talk on the phone if you're comfortable doing that. Or you can call Mr. Rosenblum, whatever works.
Okay, that'll work.
Okay, we'll tighten that up in just a second. Mr. Rosenblum, anything else on behalf of your client?
Your Honor, and we appreciate the sentence recommendation, the sentence that you handed down today. I think it's just, as far as November 2nd, I don't think you have anything to worry about. He's got 4 monitors back there right now. We'll make sure that either I am kept apprised of any medical conditions or they will deliver him at 9:30 on that day.
I wasn't particularly worried, but I needed to impress upon Mr. Gardner the consequences of not being here. It will get stressful as that day approaches, which is why I flagged it. If stress leads to heart issues and you go back into medical care, I just need documentation of that. But my hope is you stay safe and healthy, you get the custodial portion out of the way, and you can focus on getting back to work and doing all the good things you've been doing the rest of your life. Okay?
Thank you.
All right, now, before you guys go, Ms. Crawford, what's the best way? Should Mr. Rosenblum call you, or do you want to call him?
Judge, if he can provide me with his telephone number, I'll give him a call.
Great, and she'll call you right away, and you guys can just step outside. She just needs to get information about Mr. Gardner. What's the best number for her to call?
It's 770-596-4763.
Did you get that, Ms. Crawford?
I have 770-596-47. What are the last 2 digits?
6 and a 3.
63. Thank you. I have it.
All right, and you'll be able to call Mr. Rosenblum right now?
Yes, Judge. I'm going to call him right now.
You guys step outside. You don't need to come back in. I will see at least you, Mr. Gardner, on November 2. Don't bring a big suitcase, all right? All right.
Judge, I need to confirm something. I just want to make sure I got it right. Did you say the counts that were 30 days to serve concurrent are counts 4, 6, 7, 8, 9, 10, and 11?
Correct. I believe those are all the misdemeanors. And then
Okay.
the 4 felonies are concurrent with each other, but consecutive to count 4.
Okay, thank you.
You're welcome. All right, let's have a quick conversation with Ms. Patel, since she tracked down Ms. Hubbard, and then we are going to turn to Ms. Convery's matter. Hello, Ms. Patel.
Hello, Judge.
So you found Ms. Hubbard, and there's Ms. Hubbard. Hello, Ms. Hubbard. You're on mute right now.
Ms. Hubbard, you're on mute. Can you unmute yourself?
Okay.
Okay, there we go.
All right, so we missed you this morning, Ms. Hubbard. You doing okay?
Yes, sir, I am.
Did you know that we were hoping to chat with you this morning?
Yes, but I was given the wrong information.
Okay, what were you given?
I was given the wrong meeting ID and passcode.
Okay, so you were trying to dial in and it wasn't working,
Yes, sir.
or you were showing up in a courtroom in Minnesota or something. It just wasn't our courtroom.
Yes, sir.
Okay, so Ms. Patel, my recollection is that you sorted something out in Ms. Hubbard's single defendant case, which is with Ms. Sellers as the prosecutor. And then you have a long list of missing discovery in the shooting case.
Yes.
Correct, but I do have to speak with Ms. Sellers about what Ms. Hall and I spoke about, so I'm not sure if it's really worked out just yet.
Okay, and either way, the shooting case was not worked out. But Ms. Hall is going to work to get you more discovery, and we just need to make sure Ms. Hubbard keeps us posted as to how best to reach her, so that next time she needs to join us in person or via Zoom, she's able to do that. What is the case number? One of Ms. Hubbard's case numbers? Does either of you have that?
One of them is 19 SC 170770.
Great, thank you. Got it. That's from several sources. So, Ms. Hubbard, I just want to make sure that we've got a good address for you. Do you still live on Sims Street?
No, sir.
Okay, so we're going to need to get a new address, Ms. Patel. If you could get that from your client and fill out a change of address form and get that to Ms. Nelson, and we'll have a good address for Ms. Hubbard, because the system has her at 3289 Sims Street.
That's my mailing address, but that's not where I stay at.
Oh, well, I didn't ask the question well. If I wanted to mail something to you, should I send it to the Sims Street address?
Yes, sir.
And how does it get to you?
Through my sister.
Okay, so that's where your sister stays, and then she'll say, hey, Ms. Hubbard, you got some mail from the judge.
Yes, sir.
Okay, all right, then we don't need to change anything. We're good. All right, then Ms. Hubbard, Ms. Patel will let you know what's coming next. She needs to talk to another prosecutor, and she needs to get some more information about the case in which the gentleman got shot. And then we'll talk to you again, okay?
Yes, sir.
All right, Ms. Patel, anything else with Ms. Hubbard?
No, Your Honor.
All right, we will not do a bench warrant.
Thank you, Judge.
All right, take care. Ms. Hall, thank you for staying on. I think the remaining matters with Ms. Convery. Do you have anything else?
No, I have nothing else, Your Honor.
All right, I think next week is mostly civil stuff, so you get a little break. We've been doing lots of good work. Ms. Nelson shared with me the progress we've made on some of our old cases. So thank you for working hard on moving some of your caseload.
You're welcome.
All right, we'll see you whenever we have another criminal calendar.
27th. Have a great week.
Enjoy the break.
All right, thank you.
Go do some discovery.
Okay,
Bye.
bye.
All right, I think we're going to keep the, bye, Ms. Hubbard. I think we'll keep the Zoom going because Ms. Nelson will need to listen in. I don't see Ms. Rolak, so there's no victim witness situation going on. No, right with that? Okay. Then let's shift gears. Read it out. All right. I believe, are you good to go, Mr. Forte? So we're here on 18 SC 162228. Which is state versus a whole lot of people. One of them is Terrell Chambers. I've revoked his bond. So that's not who we're talking about. Another is Mr. Job or Jobe, and you've withdrawn your motion to revoke his bond. Wrong social media account. And he's locked up somewhere. We have a bunch of Jacksons. And I think we're dealing with Quintavious Jackson today. Okay. Mr. Bowles, how are you?
I'm well, Judge, how are you?
I'm well, good to see you. Are you Quintavious Jackson?
Yes.
How are you doing, Mr. Jackson?
Good, how are you?
I'm okay. We're going to talk, Mr. Jackson, a little bit about the state's motion to revoke your bond. You are on bond in a case with some pretty serious charges that has some pretty specific conditions as to what you should and should not do while you're on bond. And if I recall, I'm gonna pull it up here. Let me ask this first. Are you related to Quentin Jackson?
Yes.
How are you related to Quentin?
My brother?
Are you related to Tiana Jackson?
Yes.
How related?
My sister?
Right? Do you have other brothers and sisters, or is this all the Jackson siblings?
I got one more sister.
Okay. She's not in this case?
No.
All right. Let me get to you. Here you are. All right. I'm gonna call up the motion because I just printed out the text. I think we've got pictures. But your bond, you got a $70,000 bond in June of 2018. Before I was involved with the case. You posted that bond on the 4th of July, or at least you got released on the 4th of July, it says in here. And something happened in September of this year that we're going to talk about. But one of the conditions of your bond was that you shouldn't get arrested for anything. And you also were to not continue to associate with folks like your co-defendants, Mr. Chambers and Mr. Joe. And the state is contending that you have engaged in some conduct that's not consistent with the bond. So I'm going to hear from Ms. Convery about that, and I will certainly hear from Mr. Bowles, and then we'll figure out if you keep your bond or if I revoke your bond, okay? All right, Ms. Convery.
I'm going to ask for some guidance for the court about how much the court would like to hear about the new offense. There is an active warrant right now for Mr. Jackson based on the Sandy Springs warrant that I referenced in the motion. So I'm prepared to call a witness and offer the court some testimony about that offense. I'm also happy to offer a little bit to the court about what I'm alleging that violation is. And it's the same for the Instagram information.
So let's just start with the active warrant, because that may sort of make moot anything else, whether Mr. Jackson won the Nobel Prize or got arrested for shooting at the governor. Have you been able to share with the sheriff deputies that are here that there's an active warrant for Quintavious Jackson's arrest?
Yes.
All right, Mr. Bowles, we may need to discuss other aspects of Ms. Convery's motion, but I don't know that it would be appropriate for me to let your client leave the courtroom if there's an active warrant for him. If you know that there's not an active warrant, then we need to work through that. But that seems to trump everything else that Ms. Convery may want to talk about, or that you may want to say in response.
Well, Judge, it's my understanding that there is an active warrant. I've gotten some information on the basis of that warrant, but I guess it would be up to the court or Ms. Convery to verify that it is an official, legal active warrant, but it is my understanding that it is one. I have communicated that to Mr. Jackson before we came to your courtroom, before today, and I understand the court's position, but I am aware of it.
Okay. Well, then I guess what I want to ask you, Mr. Bowles, is do you want to, we can confirm the warrant. We'll do that. And it may be that is there something you need to give to the deputies? He seems to be looking for something.
Yeah, I spoke with them before. It's my understanding they kind of knew before I even entered the room. Okay, that's a misunderstanding on my part. There was a phone call that was made, but I ran.
Okay.
Yeah.
Well, let's, if you don't mind confirming through your systems, if you're able, the currency of the warrant. In other words, it's not expired. You've got the right gentleman here. Let's do that. And then really, Mr. Bowles, I'll defer to you rather than you defer to me. We can have this conversation now, but it's kind of moot. If you think it would be helpful to your client to have me hear about like the photos that are attached or what's been going on with Instagram, I'm happy to hear about it. I don't know that it would be helpful, but it also doesn't matter at this juncture. I could conclude that that's a toy gun in the picture, but the Sandy Springs warrant, whoever's warrant it is going to tie my hands. So my thought is maybe we wait to talk about addressing a new bond after you've had a chance to digest what's behind this warrant. Obviously, right now, your client can't get formal charges out of the new warrant, although in November that'll change, because there'll be a grand jury here. So that seems where we are. Do you agree?
I agree.
Why don't we sit tight and see if they can confirm the warrant? And I know we have an officer or higher rank from Sandy Springs, and so it could be that it can, some kind of law enforcement writ, they could confirm that it's current. But let's just wait for a moment on that, and we'll go from there. I will say this, make sure it gets on the record. It is helpful to Mr. Jackson that he walked in the courtroom knowing that there was a warrant for him. When we next have a conversation about where should Mr. Jackson be spending his time as we wait resolution of this case and whatever the new charges are.
No, we're doing a bond hearing.
Hi, Ms. Nelson.
Sorry.
Household background. So that's not lost on me when we next need to talk about what's going on. I skimmed it, Ms. Convery, but are the allegations behind this new warrant linked to Mr. Chambers? I'm remembering Mr. Chambers. You gave me all sorts of information about Mr. Chambers and why his bond ought to be revoked. Is this connected or not connected?
Yes, it's connected, but it's also complicated. Mr. Chambers ended up being taken into custody on an City of Atlanta warrant for a completely unrelated matter. Continued investigation, including phones and an interview of Mr. Chambers. We actually now have Xavier Smith in custody, and he'll be Mr. Jackson's co-defendant when ready with that case.
Okay.
But
This
yes,
involves
it's a
the
factual basis.
fancy rental cars.
Yes.
Okay. All right. Mr. Bowles, have you represented Quintavious Jackson since this case got indicted, or are you new to have you been working with Mr. Jackson on this case for a while?
Yes, Judge, I was the attorney of record when we acquired the bond.
Okay. Any reason why a 2018 case is at this point, other than some cases don't move quickly?
Yeah, it was different judges, because it was before, it was, last time when we were here was a reader, right? Before that, it was.
Well, Downs' cases went to Reader, Reader's cases went to me, but cases are still supposed to, in theory, keep moving, even though they bounce from judge to judge. I just was curious. I know it's a bunch of defendants, so that makes it harder to move the case along. We don't have a lot of 2018 cases anymore.
I think there might have been an issue with somebody else getting an attorney, because it was a C3 issue. There's only 3 of us.
There have to be, yeah. I mean, there's 6 or 7, there are 5 or 6 defendants. Okay. All right. What did we learn?
It's a firm out of Sandy Springs.
Okay. Are you able to take Mr. Jackson into custody based on that warrant?
Based on that warrant, yes.
Okay. Why don't we do that? And then Mr. Jackson, after Mr. Bowles has had a chance to understand a little bit more what's behind that warrant, then we should keep talking because that's going to affect what we do with this situation as well. I will temporarily, so there are no surprises here, I'm going to, I'll use the word provisionally. I'm going to provisionally revoke the bond in this case so that Mr. Jackson, should a magistrate set a bond that Mr. Jackson can make on the new warrant, he doesn't go anywhere until the 4 of us can have a conversation about what the consequence of the new arrest should be in this case. But I'm available. That doesn't mean, we'll see each other in January. If Mr. Jackson and you, Mr. Bowles, are comfortable with Zoom, it can be via Zoom. Every Tuesday, I have inmates brought over. Tuesday's my day, I have inmates brought over. So the longest wait would be Tuesday. And then there's this, you know how it works, but there's this cycle of Zoom calendars where judges get a slot out at the jail. And it could be that Mr. Jackson, through you, waives his presence. And then it could be any day that you could appear or Zoom in and this conference is available. So I don't mean to delay anything, but I am going to freeze things. And so I will revoke Mr. Jackson's bond provisionally in the 18 SC case because in front of my own eyes he's being arrested. But I appreciate there's more to it than that. Then we ought to have a conversation about it. So we'll regroup, but only after Mr. Bowles, you feel like you've got enough info to speak meaningfully about the new case. I figure you're ready to talk about the Instagram and this and that. That to me is small potatoes compared to an active warrant. Okay? Okay. All right, Mr. Jackson, we'll see you soon. All right.
And I am working on solving this one. I know it's old, so.
That's
For everybody.
Is Mr. Abate still here or did he run out? He left.
I can't see me back in action, it's live and forward.
Yeah.
So Judge, do you do a special order on that provisional revoke the bond?
No, we'll just do a revocation, so I don't know if you've got something, or if I need to do one. But I just wanted to get on the record that it's provisional, meaning it's a revocation, but it's something that we can revisit right away. Often if I revoke a bond, I'll tell the defense attorney, we don't need to see each other for a while on this one. But this was sort of a real-time arrest, so the language would be the same as being revoked because Mr. Jackson was arrested for new criminal conduct. I just don't remember if I do those or you do those.
I think you do those because it's different.
Okay, I'll do it.
Thank you.
You bet. Thanks, Ms. Crawford. Hey, did you get what you needed from Mr. Gardner and Mr. Rosenblum?
Yes, I have everything that I need. I'm just waiting for you to sign those sentence sheets so that I can send them over to archives.
Well, I signed Mr. Williams's. I won't be signing.
Mr. Gardner's until later.
Yeah, exactly.
Okay.
Right?
Oh, all right.